Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, as long as they are legal questions, I should be able to deal with them live on air. In order to contact me, you can call on the landline number that appears at the bottom of the screen. Alternatively, there's a mobile number there, and you can send us a message, a WhatsApp message or a text message on the mobile number which appears at the bottom of the screen. When you send that message, the message will be fed through to me here live on air. I'll be able to see your question as it comes in, and I'll be able to answer the questions that you've raised, the queries that you have live on air. A couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. Sometimes matters are quite complex, and I need to take very detailed information from callers who call in. If it's the case that your matter is complex and I need to have an in-depth discussion with you, then I'll ask you to leave your number with the control room and I will give you a ring off air, and then we can have that more thorough discussion off air. Similarly, sometimes I do need to look at documents before I advise further. For example, if you've received a refusal letter from the Home Office, sometimes it's helpful if I have a look at that, and then I can advise you properly on the contents of that letter, what your next steps are, etc. So likewise, if it transpires that your matter is complex or I need to look at the document that I have, then I'll ask you to send that in and I'll have that more thorough discussion with you off air. Okay, let's go to the first caller of the day. Hello, assalamu alaikum.
Wa alaikum assalam wa rahmatullahi wa barakatuhu.
Yeah, thank you, brother, for calling.
Yeah, I it's Department for Works and Question, Works and Pension.
Okay.
And they said that changes we need to know about.
Okay.
And it says failure to tell us about a change you know affects your entitlement could result in prosecution. Well, the only thing that I'm worried about, because when I fill in the form, they ask the question about whether you're a director of a company.
I understand.
So my wife is a director of the company, but my accountant, who's a relative, said, well, because you don't get any director's fee or any money out of the small limited company,
I understand.
You'd put no.
Okay.
But I'm reading the thing again, and it says if you are appointed as the director, or you start to receive director fees, I need to inform them straight away.
Okay, I understand.
Now, my wife has been claiming carers allowance for about 3.5 years now.
I understand.
And now I'm reading this again. I'm getting very concerned and worried.
Okay.
That I really need to talk to them about it. But
I understand.
Since she's not getting any director's fee or getting any money out of the limited company, should I still have to tell them? And if I do tell them now, what is the likely penalty or problem? Or should she just cancel being a carer?
Okay. What kind of benefits are being received at the moment? She's
getting no benefit, nothing at all.
Okay.
She's looking after me.
Okay.
I'm getting attendance allowance, and she's my carer.
Oh, and she
gets no other benefit.
Okay, so she gets carer's allowance. Is that it?
Yes, £270 a month.
Okay, all right. Look, my view is this: that if the question is, if you're are you a director of a company? Then clearly the answer to that is yes. Obviously, in terms of remuneration, whether it's dividends, whether it's salary, or some other kind of payment for the role of director, that's a separate matter. Payment is a separate matter. If the question that's been asked is, are you a director of a company? And the answer to that is yes, then you should answer in the affirmative. You should say you're a director in the company. Now, if you haven't done that, I don't think there's any harm in informing them now that you become aware that you should be informed of the directorship. I don't think there's any harm there at all, because in the end, the issue is, do you receive any money as a result of it? And if you're on carer's allowance, you're entitled to receive. I know your wife doesn't receive any money at all, but you're entitled to receive up to £128 a week anyway under carer's allowance. So there's no harm in disclosing it. At least it puts your mind at ease, and you've not hidden anything from them at all. You've been upfront. There's not going to be a prosecution, because no money's been earned through there. Nobody's been defrauded. They haven't lost out. So there's definitely not going to be any kind of prosecution at all.
Yeah. Well, I put no when the question was asked, and I was a bit worried about it. So I asked my accountant relative, and he said, put no, because you're not going to get any money.
Okay. I think it would have been better to say yes and then say, I don't receive anything at all. So can I just ask you this? Wife is a director. Why does she not receive any money from the business at all? Is it because that she doesn't do anything from the limited company, or is the limited company making no money at the moment?
She doesn't do anything in the business. It's just my son. It's my son's business.
Just a statutory director.
He's a sleeping partner. That's what it is.
I understand. So would you, does she need to remain a director of the company, or would it be easier if she came off as a director?
Well, because I was thinking of getting her to come off, but because of this COVID lockdown and that the business, both businesses, for which my wife is one of the directors, only one director for the one small business, and my son is a director for the other business. Because they got some grant, or they're getting some help, I think, from the government because of COVID. Yeah. I was going to hope that it's going to drag on for another month or two. Okay. When this thing comes off, then I was going to take her off this carer allowance. Okay. But if it's safe to take her off now, then I'll do that. But if I can let her stay on, it'd be better for her to stay on. I prefer her to stay on, because she doesn't have any other benefit. We don't claim anything else. I'm only getting attendance allowance, and she's getting carer allowance to look after me. Okay, but in terms of her directorship, does she receive anything at all as a result of being a director? Not a penny. Not a penny. Okay. Not a penny. Okay. Okay. And all she does, because she's the director, we got a checkbook, and she just signs whenever my son wants any check signed. She just signed it. But I think it's a very small company. It's not making a lot of money. I understand. Look, the only thing is this. If you do say to DWP that wife is a director in the company, they might ask you a few more questions about her income. So it's just that might open up a line of inquiry. They may ask questions which you might have to deal with. But based on what you've said, if you do deal with those questions, if you explain there is no dividend being declared, there's no salary, they'll just leave it at that. They'll accept it as simply being a statutory directorship where no remuneration is being received. See, my view is, look, if this is concerning you, disclose the fact that she's a director. I cannot see there being any kind of investigation or prosecution at all, because nobody's been defrauded here. Would it be a better idea for her for me to take her name off, and after a couple of months apply again, and then declare she's the director? I honestly don't think that makes a difference. I honestly don't make. If you feel more, because the point here is this: that she never received any money at all. She hasn't received any money at all. See, that's where the problem arises. Let's say from her directorship, she was getting dividends, or she was getting a salary, and that exceeded £128, which is the limit, £128 a week. That's where the problem was there. So that has never happened here. So that's why I can't see a problem with saying to them that she is a director. In the end, nothing can go wrong here, to be quite honest. Because might be. My thoughts are maybe I ought to leave it a little while, and if they do find out then I'll tell them, or it's best to go and tell them now?
I mean, look, they would only find out, or they would only check if there's a reason to carry out a check. And once somebody has a reason to check whether somebody's a director or not, it's very easy, because this type of information is available on Companies House website. So it's very, very easy to check. If I put my name in, if you're a director of a company, if I put your name in, it'll come up on Companies House straight away that you hold a directorship within a company. So if they do check, it'll come up straight away. Now, why would they check? There seems to be no reason for them to carry out that check. But again, to be on the safe side, there's no harm in being upfront and telling them now. Now, your idea that, okay, she ceases to be a director now, fair enough, and then when she decides to go on as a director, you inform them, then that works as well. But it might be better simply to inform them of what the correct position is. There won't be a problem. I cannot see any kind of prosecution. I cannot see her benefits being reduced or taken away as a result of it, because there's no income from that directorship at all.
Thank you very much.
No problem at all. Thank you very much for that question.
Thank you. Thank you for your advice.
No problem at all.
I'm grateful.
Thank you very much. Interesting question on slightly unusual issue relating to benefits and what needs to be disclosed. And my advice always is this, that it's always better in the long run to be upfront and to tell DWP the position as it is. If facts are concealed and they come to light later on, then, as our viewers might be aware, two things can happen. One is there is obviously the possibility that if money has been paid out, which shouldn't have been paid, that will be clawed back. And the second more serious matter is that they may look at a potential prosecution. So always better to be upfront and honest with them. That brings us to the first break. We're going to be back in the next couple of minutes. We'll be back and see you then. Assalamu alaikum. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please ring on the landline number that appears at the bottom of the screen. Alternatively, as always, you can send us a message on WhatsApp on that mobile number, which is also at the bottom of the screen. I think we've got a caller waiting, so let's go to our next caller. Hello, assalamu alaikum.
Wa alaikum salam. Actually, I have a question about my wife's visa. She has now indefinite.
I understand. Yeah.
And she's about to apply for the passport. So will she still need a requirement for the work or any
No.
like financial requirement, or
No.
she doesn't need any financial requirement?
So in terms of the financial requirement, there is no financial requirement at all. But when you complete the online form or the paper form, you'll notice that they ask about employment history. So they ask,
Yes,
yes, where have you worked in the last 10 years? Where did you work? Dates of employment, what did you do? But to be quite honest, they're not asking about whether you're earning money or whether you're meeting any kind of financial threshold or not. That simply does not apply at all at the nationality stage. Obviously, you've been through that process of a spouse application, the 18,600 requirement.
Right.
Yeah. So you're used to that entry clearance application, extension, indefinite.
All right, so we can write no at the moment we are not working. If we are not working,
100%.
Actually she's not working at the moment.
Absolutely.
So she can write she's
100%.
not working.
It's just the financial requirement simply does not apply at all here.
So it's absolutely fine to write no.
100%. Now, don't be concerned about the questions relating to work history. And then towards the end, they'll say, or send us some proof of your employment history, like P60s and wage slips. Again, don't be concerned about that. If you have any historical documents, put them in. There is no requirement to submit the last 6 months' wage slips or anything like that. Don't be concerned when you get to the end and it says, send us your P60s and wage slips. That's
all right. So because she is getting confused of this question, and she was thinking that they're asking this question for a purpose, and they might need the requirement.
No.
So,
On that point, sometimes the best thing to do is there is a very good guide on nationality that the Home Office has on their website. A very basic guide. So I think if you, because the form that you're filling in at the moment is Form AN. Now, I think if you Google Form AN Nationality Guide, the right PDF document should come up. That tells you all the requirements. And I can assure you 100% that there is no financial requirement at all. In fact, somebody who's never worked a day in the United Kingdom, they can still qualify for nationality because there is no financial requirement at all that applies.
All right. Thank you very much, Jazakallah.
No problem.
That's a curiosity we're facing.
All right, no problem at all. Thank you very much for your call.
Okay, Jazakallah. Assalamu alaikum.
My problem. Alaikum salam. So, question relating to nationality. In fact, a common question on nationality. I think it arises because of the way the paper form, the online form on nationality is designed. It asks questions, quite detailed questions about one's work history. So people obviously think that if it's asking questions about work, it must be the case that you need to be working. There must be some kind of financial requirement there. And as I explained, when you come to the end of the question and the sort of document checklist which is generated, which is the documents that you need to submit. When you look at that, again, it talks about your P60s and your wage slips, but that's historical documents are fine. And as I said, in answer to the question, even if you've never worked, it doesn't matter because there is no financial requirement for a nationality application. One of the things that you need to be aware of, I think the reason behind the long detailed history that's been asked is that if somebody has undertaken work when they shouldn't have, so they were a student without right to work, or they had some other kind of visa which didn't allow work, or indeed they were without a visa and shouldn't have been working. Now, if the Home Office realizes by looking at the work history that work has been carried out during a period when you shouldn't really have been working, then you can be penalized for that. The way they do it is simply to say, well, look, you know what? You breached immigration conditions during the last 10 years of your residence in the United Kingdom. You worked when you shouldn't have been working, and therefore we're not prepared to grant you British nationality because you're not somebody of good character. So really, the work history, I think it's more to do with looking at whether employment in the United Kingdom over the last 10 years has been lawful or unlawful employment. It's got nothing to do with meeting some kind of financial threshold, which our viewers who've gone through this visa process will be well aware of, that at each stage, generally speaking, with the vast majority of applications, there is some kind of financial requirement, some requirement relating to savings, but that does not apply to nationality applications at all. So hope that answers that question. As always, to give us a ring live on air, please ring on the landline number that appears at the bottom of the screen. Alternatively, the mobile number is there for you to send us any messages that you have. Let's look at some of the questions that have come in. Let's look at the next question that's come in on WhatsApp and let's address that. But by all means, if you want to give us a ring live on air, please do so on the landline number. Okay, question that's come in. The question is, my daughter is married under Islamic law in the United Kingdom with a person who's from abroad. That person is here on a student visa studying at Huddersfield University. He's got 2 years left with his student visa. My daughter is expecting their first child in December. Where does the student, the husband, is married under Islamic law, where does he stand in terms of applying for a visa here? Can he do it here, or does he have to go back to his home country? Interesting question. It's an issue that comes up quite regularly, where there is somebody here in the United Kingdom. In this case, the lady is here in the United Kingdom, a British citizen who enters into a relationship with somebody who's from abroad. And this person happens to be a student in the United Kingdom. And obviously, when the students in the United Kingdom, they will be here with a limited visa. Question that's been posed really is, can that person continue to stay here? Now, the short answer to that is yes. And there is a process for doing this. And if you follow the process properly, there shouldn't be any problem with transferring. This is the student transferring from a student visa to the marriage visa based on the marriage to the lady who's here. So there's a process that needs to be followed. So the first step really is this, that they should ideally register their marriage in the United Kingdom. So here they are Islamically married, but that isn't enough. They should register their marriage at a civil registry office. So students can marry in the United Kingdom without any difficulties. There are only a certain number of categories of people who are in the United Kingdom who are prevented from marrying in the United Kingdom. The main category is somebody who is here as a visitor. A visitor cannot get married at a registry office in the United Kingdom. It's against the visitor conditions. So that doesn't apply here. The person is here as a student. So the first step is they should register their marriage at a registry office in the United Kingdom. Now, once that is done, the student can switch from the current student visa into a spouse visa. Now, once the application is made to switch, there are obviously certain conditions which need to be satisfied as part of that application for that application to succeed. The main requirement is the financial requirement. So the £18,600 requirement, which applies to most spouse applications, generally would apply here. There are some exceptions, but generally the requirement is that individually or jointly, the parties should be earning £18,600 per annum. Now, so tactically what you would do is this. In terms of registering the marriage, there's no problem. You should register the marriage now. But when it comes to the student who's here submitting an application to switch from the student visa into a spouse visa, you're going to have to time it right. You're going to have to time it in such a way that you only submit the application once the financial requirement is met. And normally, you need to submit 6 months of wage slips, 6 months of bank statements. So you would wait until the individual income or the joint income combined over a period of 6 months is equivalent to an annual salary of £18,600. So let's say the marriage was registered now in June 2021. You start getting your employment documents sorted out. You wait until December 2021 or January 2022. That's given you a good 6-7 months to sort your employment out. So individually or jointly, as long as you've got enough income there, it's at that stage that you would look at submitting the application. So in terms of registering the marriage, that can be done now. There's no problem. In terms of submitting the application, normally what delays that application is really the parties waiting until such a time that the financial requirement is met. Now, fairly straightforward. In this particular case where we've been asked this question, the visa is for, the student has a visa for another 2 years. So there's a lot of time to plan all this out. There may be other circumstances when there isn't enough time because the student is on a student visa which is about to expire within a month, within 2 months, within 3 months. Now, in those circumstances, I think it is slightly more difficult because you're trying to get the marriage done. You're also trying to meet the financial requirement and to get your application in. Sometimes that limited time that you have of 2 to 3 months may not be enough. It depends on your circumstances. Now, there are different options. There are ways around this. so that ultimately a successful application can be made from the United Kingdom. Now, if it's the case that you're in difficulty because there's very little time left before the student visa expires, then you should take advice from an experienced immigration lawyer who can advise you on your options, because there are a number of options available. I hope that answers the question. We're going to be taking a short break. We're going to be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live, please ring on the landline number which appears at the bottom of the screen. Alternatively, you can send us a message on the WhatsApp number, which is also at the bottom of the screen. We've had a number of questions coming in on WhatsApp already. Let's turn to them. So let me deal with some of the WhatsApp queries that have come in. But by all means, please do feel free to pick up the phone and give me a ring directly on that landline number. Okay, let's look at the next question. And our viewer who's texted in says, I have a few questions. My brother was married in Pakistan a few years ago. He submitted the forms and legal documents. Whilst they were there, the relationship broke down. However, the visa was granted to the girl. The girl did manage to get a spouse visa, and she is in the United Kingdom at the moment. But we didn't know that she came to the United Kingdom. The relationship has broken down. Brother wants a divorce. How does the divorce procedure work as she is now in the UK? Also, are there any consequences regarding this? Now, in terms of the marriage, here it looks like the brother's marriage took place in Pakistan. A marriage that takes place in Pakistan, an Islamic marriage that takes place in Pakistan, which is registered, is regarded in the UK as a valid legal marriage. Sometimes people think that, oh, well, we only got married in Pakistan and it was an Islamic marriage, so it's not really going to be recognized as a legal marriage. That's not correct, actually. A marriage in Pakistan, and all marriages in Pakistan are more or less registered, either with the Union Council or if it's in Azad Kashmir with the Tehsil Mufti office. These marriages, Islamic marriages, which are registered, are actually valid marriages as far as English law is concerned. So it's regarded as a valid marriage. A valid marriage has to be brought to an end properly and formally. So in the United Kingdom, if you want to bring it to an end, you can't simply go through a Sharia council, or you can't simply give an Islamic talaq and expect that marriage has come to an end. That simply brings the religious marriage to an end. It doesn't bring, as a matter of English law, the actual valid marriage to an end. For that to happen, you have to go through the court process. Either you go through the family courts in the United Kingdom, or alternatively, in certain circumstances, you can go through the formal system in Pakistan, whether it's the court or whether, again, it's through Azad Kashmir, whether it's through the Tehsil Mufti office. So one of those two things will have to be done. The marriage which is recognized, that Islamic marriage which is recognized as a legal marriage, will have to be brought to an end legally here through the family courts in most circumstances. In limited circumstances, you can use the formal process back in Pakistan. Now, a couple of issues arise here. First of all, the girl seems to be here. We don't know how she's managed to get here. If it's based on the sponsorship of the brother, then the Home Office should be informed that, look, somehow she's managed to get here. And as far as our relationship is concerned, it certainly doesn't exist. and her visa should be curtailed. So one is an immigration point of view. Now, it could be that she's in the United Kingdom on some other basis. It could be that she's in the United Kingdom as a student, as a visitor on a work permit. So we don't know how she's here, but if she's here based on the brother's sponsorship, then the Home Office should be informed about the fact that there is no relationship subsisting at the moment, and they should make a note of that and curtail her visa. So that's the immigration aspect of it. Now, how do you then bring this marriage to an end where you don't know where the lady is? Now, this situation does arise in practice where the parties previously married have split up a long time ago. And it could be for the last 5 years, 10 years, or whatever it is, they've been leading absolutely separate lives. There's no overlap in terms of friends or family. So neither party really knows where the other is. They might have a vague idea that they might be in England, they might be in Pakistan, UAE, wherever it is. But they don't know what the address is for that person. And more importantly, they have no means of finding out what that person's address is. Now, obviously, the court system recognizes this, and there is a system in place which deals with this particular situation. So what the court normally wants you to do is to take all reasonable steps possible to bring to the attention of your partner, your ex-partner, the fact that you're divorcing them. So in terms of the divorce petition, that is normally served on your partner. The court needs to be satisfied that everything that can possibly be done has been done to bring that divorce petition to the attention of your partner, your ex-partner. So there are certain things that you need to do in order to satisfy the court of that. So it may well be that the court says, what attempts have you made to contact relatives or friends of that person? Have you advertised anywhere the fact that you're bringing the marriage to an end, etc. So there are some steps that you would need to take. Once you've taken those steps, and at the end of the day, it still hasn't been possible to bring to the attention of your former partner the divorce petition, the fact that you're going through a divorce. After you've taken all those steps, it's still not possible to trace your partner. The court may be willing to accept that the service of the divorce petition on your ex-partner should be dispensed with. So you can proceed to the next stage of the divorce, even though it's not been possible to serve the divorce petition on your partner. So the court recognizes the difficulties in serving divorce petitions on former partners, especially where there's been a long gap between the relationship breaking down and now you making the application for the divorce. So in my experience, this is slightly complex. So ideally, you shouldn't attempt to deal with it yourself. Ideally, you should engage the services of a specialist family lawyer in whichever area you live, and take advice on the steps that you need to take. Practical steps, you think about it. What can you do to bring to the attention of your former partner the fact that you're going through a divorce? Maybe you can go through family, you can go through friends to notify your former partner, or ultimately it may be that the court says, well, you know what, the fact that you're going through a divorce needs to be advertised in some formal paper. It's like London Gazette or something, where the divorce proceedings have to be set out. So that's basic steps that are followed through in order to get a divorce. Okay, let's take the next call for the day. Hello, Assalamu alaikum.
Wa alaikum assalam.
Yeah, thank you for calling. Gee, what's your question?
Hello.
Hello, hi. You're live on air. What's your question?
Yeah, my question is, I come in this country from Pakistan, yeah?
Okay.
So my extension is due, yeah?
Okay.
In coming months.
I understand. Okay, that's fine. Yep.
So I had in UK degree, yeah?
Yep, UK degree. Yep.
So for that reason, I need to pass IELTS B1 exam.
Okay, so you know,
Just
okay, so you know your degree. Which is it from a UK university? Your degree?
no. Basically, I qualified dentist from Pakistan. Yeah. I
Okay.
also got the dental hygiene registration in UK.
Okay, all right, okay. So you know your degree qualification. Is it from Pakistan? Did you say?
Degree from Pakistan. Yeah.
I understand. Okay, all right, okay. Now you can use your degree from Pakistan if you want to, but there is one additional step you need to follow if you want to use your degree from Pakistan, which is you need to contact UK NARIC and get your degree looked at by them. So what they do is you get your transcript, you get your degree certificate, you send it to them. They look at it and do a statement of comparability. So they look at it to say whether that degree in Pakistan is equivalent to a UK degree or not. That's the first thing they do.
Yeah, I have a NARIC certificate.
You've got the NARIC, yeah? And the second thing that they do is they confirm whether the degree was taught in English or not. So there's two things there. One is the statement of comparability. The other is confirmation that the medium of instruction was English. Have you got both of those?
I taught in English.
Okay, so if you've got both those documents, statement of comparability and confirmation that the medium of instruction was English at the required level, then you don't need to do a B1 test in the UK.
Okay, that's fine. So one more thing.
Sure.
NARIC statement I got 2 years
That's
before.
fine. There's no problem. There's no problem. Yeah.
Okay, that's fine.
Yeah, but you know what you need to be aware of? Okay? It's not just the statement of comparability that you need. You need the second bit as well, which is the degree was taught in English. So there's two things that you need from UK NARIC. So you just need to be...
Okay, that's fine. You will just need to give the proof of these two things. Yeah?
And those two things, both of them come from UK NARIC.
Okay, that's fine.
Okay, brilliant. So,
Okay,
thank you.
Okay, that's fine.
It's okay. Thank you very much for your question. So, question about the English language requirement. Yes, we normally say that, you know what, you need to get certain certificates in English at the initial stage A1, at the extension stage A2, at the indefinite stage B1. These are different certificates that you get normally from a college called Trinity College here in the UK. But there are exceptions to that, especially where somebody is degree educated. If you've got your degree from the UK, simple, you don't need anything else. If your degree is from abroad, like our last caller's degree was, then there's some additional steps you need to take. If your degree is from abroad, you have to contact UK NARIC, get confirmation that your degree is at the right level and was taught in English. But thank you very much for that question. That brings us to a break. We're going to be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please call on the landline number that appears at the bottom of the screen. Alternatively, as always, to send us a WhatsApp message with your question, please do that on the mobile number that appears at the bottom of the screen. We've had a number of WhatsApp questions coming in. Got quite an interesting question, quite detailed question relating to finances upon the breakdown of marriage and whether, given these quite complex circumstances, it's worth pursuing a financial claim following a breakdown of marriage. Now, our viewer has gone to a lot of trouble to explain the circumstances in a lot of detail, and I think it's only right that I try and address that as best I can. So the very basic circumstances that our viewer has written in about relates to a marriage that took place here in the United Kingdom. The marriage, unfortunately, has broken down. It appears that from the marriage that there are no children at all. It doesn't seem to be a property as well. What the issue really relates to is two different sums of money. £10,000, which the wife lent to the husband during the marriage. And the second is to do with what's been referred to as haq maher, the maher that's given of £10,000. So there's two sets of money. The question is really, following the breakdown of marriage, is it going to be possible to recover this sum of money from the ex-husband now, who ex-husband seems to have, it looks like he has actually moved to Pakistan and he may well have remarried. So the real complication is, even if such a claim, really this is what you've got to think about, and this is what I always say to clients when they're looking at pursuing a civil claim, that even if your claim is strong and it succeeds, so somebody owes you money, there's a lot of proof there that the money is owed to you. So you've got a good, strong case. There's no way that the defendant can wriggle out of it. But that's all well and good. Let's say you win your case, you get judgment against the person who owes you money. And if it's for £10,000, £20,000, whatever it is, that's all well and good. But the problem is this, that if you have a judgment which you can't enforce, because the person might be here in the UK but has no money, or they're living abroad and it's going to be very difficult to enforce a judgment in a foreign jurisdiction. So if you've got this judgment, it's really an empty judgment. It's a piece of paper which says that person owes you X amount of money. But getting that money is obviously another matter. If you can't enforce the judgment, if you can't recover that money, for whatever reason, because maybe they have nothing or because they're abroad, so that judgment that you get doesn't really help you at all. It only works where you're able to enforce it, and that money that's owed can actually be recovered. Now, this is the problem that I see with this particular query, that following the breakdown of the marriage, where the husband has now left and gone to Pakistan, even if you've got a fantastic claim against the husband, bearing in mind the claim that we're talking about here, the combined amount comes up to £20,000. 10,000, we say the money was lent to the husband. Another 10,000 was the meher that was given to the wife, or not given to the wife, which the wife wants to now recover. Total sum, £20,000. If you get judgment for those sums, realistically, are you going to be able to recover it? In my view, it's going to be extremely difficult to recover that amount of money. But let's go back. Is it actually recoverable? Well, look, in terms of a claim from following the breakdown of the relationship, in terms of a normal claim for maintenance, it's going to be extremely difficult. It looks like the marriage was short. It looks like there are no children. It looks like both parties are able to work, earn money. So I can't see there being a successful claim for maintenance from the ex-husband. Now, if there were assets, if there was a house, if there were businesses, obviously that's a different picture. But here, it looks like both parties are in a very similar financial situation. No real assets, no children, etc. So in terms of the normal maintenance claim that one party would bring against the other, I can't see that going anywhere. Now, is it possible to bring some kind of civil claim? Well, let's take the easier part of the claim, which is the £10,000, which the wife says she lent to the husband. Now, the difficulty here is this, that normally outside the marriage context, if you lend somebody some money, obviously on the expectation you're going to get it back, it's a straightforward claim. The money was given on this date, would be repaid by a certain date or within a certain amount of time, hasn't been paid back, you want your money back. Straightforward. The particular difficulty here is that that money that's given to the husband, is it really lent? Is there an intention that the money would be paid back? Or is it simply a case of a husband and wife building their life together, helping each other out? like you would normally expect. So the biggest problem here is that these kind of transactions which take place within the marriage context, it's highly unlikely, in my view, for you to be able to demonstrate that this is a sum which is recoverable. So I think there is difficulty here. So not only a difficulty in the merits of the case, even if you were to succeed, I think great difficulty in recovering money from somebody who's now gone to Pakistan. Okay, let's take the next call for the day. Hello, Assalamu alaikum.
Assalamu alaikum, brother.
Wa alaikum assalam. Thank you for calling.
I have a question.
Okay.
That nowadays, how long it will take for the decision if you apply for the FLRFP
okay.
extension?
So now, you know the FLRFP extension, is it somebody who already has a visa who just wants to extend now? Or is it FLR?
Yes.
Yeah, okay, I understand. Now, typically at the moment, FLRFP extensions are taking between about 4 months to 5 months for a decision at the moment. FLRFP applications are normally the ones which take the longest for the Home Office to decide. The Home Office takes slightly longer to decide those applications as compared to other more straightforward applications. But in my experience, we're around the 4 or 5 month mark at the moment for an FLRFP application before you get your decision. More around the 5 month mark for a decision. Does that answer your question, or have you got any follow-up questions?
Yeah. Because I have already applied, and I just want to know that how long it will take.
No, you know, when you apply, count the time from when you have your biometrics enrolled. So you know when you go to the visa center, have your fingerprints taken, you should count your time from then onwards. So when did the biometric enrollment take place?
It was done in end of April.
End of April. Okay. So realistically, we're looking at May, June, July, August, about September time. End of August, around September time, you're looking at a decision.
Yeah, and what you suggest, because in August time, I have to apply for the ELR as well.
Indefinite leave to remain, yeah. Okay.
It's due in August time.
Okay. So what you would then do is, if there is no decision on the FLRFP, you don't have to wait for a decision. You can submit your application for indefinite leave to remain whilst that application is still pending. Probably that's the best way to do it. You might get a fee refund as well if you do that. So what could happen is, come August, if you're saying you qualify for indefinite leave to remain, submit your application for indefinite leave to remain at that stage. If there's no decision on the FLRFP, it doesn't matter. You still submit the FLRFP, you still submit the indefinite leave to remain application. So what the Home Office will do is they will make a decision on your indefinite leave to remain application. Once that's successful, you could potentially get a refund on some of the fees that you paid on the FLRFP. Hope that answers your question. Interesting question about delay. A lot of questions at the moment around delay coming up. On this show, we've had a number of questions. In practice, we have a number of questions around delay. And the reality is this, that if the Home Office is taking a long time to make a decision, whether it's an in-country application, whether you're extending your visa, whether you're switching your visa, whether the delay is there, or whether the delay is in terms of an application that's been made from abroad to come to the UK, whether it's a delay at that stage, the problem is there isn't much that you can do when there's a delay. There are some very, very basic steps that you can take. One is you can write to the Home Office if it's an in-country application asking for an update. Normally they won't respond. If it's an out-of-country application, there's a contact form that's filled in for an update. Sometimes they tell you that the application is in progress, but they don't give you any detailed information. So you can make that initial contact with the Home Office. If that doesn't work, a lot of time has passed, then you can contact your local MP and you can get your MP to write to the relevant department within the Home Office for an update. That is normally quite effective. If your initial approach hasn't worked, then I would, instead of getting the lawyers to continue writing to the Home Office and not getting a reply, not really getting anywhere, normally a better way of dealing with it would be to simply approach your MP after you've waited a reasonable amount of time for a decision. When the MP gets in touch with the Home Office, at least they get a proper reply. Somebody will look at the application to see what's going on and will probably give the MP some kind of guidance as to whether the case is likely to be decided or whether there's some complications, so it's going to take longer. But in my experience, that's the only way you can get some real feedback as to what's going on. It's if you get no joy from the Home Office, do get in touch with the MP or the caseworker at the MP's office. Hope that answers the question. That unfortunately brings us to the end of the show. We'll be back next week on Tuesday at 8 o'clock. Until then, Assalamu alaikum.